Welcome to the School of Law, Makerere University. I am happy to see many familiar faces, both from outside the university as well as our student body. My name is Zahara Nampewo, Deputy Dean here at the School of Law. And on behalf of the Dean, I'd like to take this opportunity to welcome you very warmly to the School of Law. Makerere University Law School is the premier and oldest law school in Uganda. Our place is renowned, and we are the leading, the most courageous, a bold pioneer on highlighting key human rights, governance, legal issues generally in the country. This afternoon, we are going to be having a public lecture on the theme, Military Courts or Kangaroo Justice, unpacking the Kabaziguruka decision. This was a judgment that was delivered on the 31st of January, 2025, after many years of waiting for this decision, a decision that had very serious implications for people that were affected by the mandate and jurisdiction of the court-martial in Uganda. The Human Rights and Peace Center, which our director will talk about, is one of those leading centers in Uganda that has taken a key role in flagging human rights and governance issues. And I'd like to thank Curipeg and the director, Dr. Businje Kabumba, together with our partner this afternoon, Conrad Adenuash Stiptang, for supporting and leading on this conversation. As a law school, we have a role to promote an understanding of legal issues that affect the public generally. The Kabaziguruka decision is one such decision. Human rights are at the core of stability and development of a country. So when you have a decision, a judgment that takes years, and people are languishing in prison, or people's legal status is undefined, that is a very grave situation. So we are happy that you are able to be here this afternoon as we go through and unpack this decision and look at its place within the constitutional area, as we talk about who are the key actors and what is the role of protection of good governance, democracy, and the rule of law in Uganda. So we shall be having two speakers. Professor Bachwinga, you're most welcome. Let me also welcome other members of the legal fraternity in your distinguished capacities. Well, according to our program, we shall have some opening remarks from Huripek and Conrad Adenuash Stiftung, and then we shall get into the gist of our discussion this afternoon. Without further ado, let me invite our host of sorts, a landlord or organizer, Dr. BK, not KB, but BK. You have to get the order right, because if you say KB, it might be another individual. Dr. Businje Kabumba, please give us your opening remarks.
Thank you very much, Dr. Zahara. Good afternoon, everyone. I'd like to start by recognizing of course, our expert moderator, Dr. Zahara Nampewa, and thank you for agreeing to do this. She's also the Deputy Dean. Professor Mbazira, Principal Emeritus, thank you very much. I know there are going to be actual introductions by the moderator, but I just thought to acknowledge your presence and thank you. Council Jude, Byamukama, thank you very much for taking the time to do this for us. I also acknowledge with deepest gratitude Professor Bachibinga, David Justin Bachibinga, thank you for joining us. Last but not least is our dear Dean, Professor Ronald Nalwairo. Incidentally, maybe I should adjust the program a bit and we have an additional welcome from a few minutes. Oh, sawa. Okay, but just to say, incidentally, why this discussion should take place here. One of the many reasons that the HURIPEC, the School of Law, is the natural home for this discussion is the fact that HURIPEC has done a lot of the work, significant work that around this area of militarism and militarization. And indeed, the work of Professor Ronald Nalwairo was explicitly cited with a significant approval by several of the justices of the Supreme Court. And for us, that is a mark of pride. It speaks to us, our work as HURIPEC and our work at the School of Law, the continuing relevance of an impact of the work here. We are very proud of you, sir. I'm also aware of the work that a lot of our colleagues at HURIPEC have done in this area, including Dr. Zahara, Professor Christopher Mbazira, Dr. James Nkubi, who just graduated with a doctorate in this area, Dr. Sylvie Namwase. A lot of work in this area has taken place at HURIPEC and at the School of Law. And really, as the temporary lead of the team at HURIPEC, it's for me a mark of great pride that this work is happening. I'd also like to thank, in a very special way, the team from, that's a very tricky word, this German word, Konrad Adenauer Stiftung, CAS, South, it's Uganda and South Sudan program. In absentia, Anna Reisman, the country representative, who is not with us at the moment, but sends her warmest regards to us all. And with us today is Sam Muhindo, the program manager media, and we are please convey to CAS our deepest gratitude for the support and partnership that has made this timely baraza possible. Now, mine is simply that, to welcome you to this baraza. It's not a time for speeches from me, but let me just say, and just following from what Dr. Zahara said, we're living in a time where certain freedoms seem to be under threat, including the freedom of assembly and also the freedom of expression. I'd like to paraphrase from Abraham Lincoln's 1863 Gettysburg Address. There he said that the lives that had been lost that day should not be in vain, that the blood that had been shed was to ensure that the government of the people, by the people, and for the people should not perish from the face of the earth. Who is trying to frustrate this baraza? In the same spirit and in the same vein, we are committed at HURIPEC to ensure that debate by the people, of the people, and for the people, on all kinds of subjects, shall not perish from the face of Makerere, Uganda, Africa, and the world generally. And with those few remarks, I thank you for your attendance, and I look forward to a very enriching discussion. Asanteni.
Thank you very much, Dr. BK. Let me also invite Mr. Samuel Muhindo from CAS to give the remarks on behalf of our partner this afternoon.
Thank you very much, Dr. Zahara. The protocol, but I would like in a special way to recognize our panelists and Dr. Zahara I have met and talked to Dr. Zara and Dr. Kavumba for the biggest part of the last half of the year. We're either discussing human rights or the future of democracy in Uganda. And in one of the discussions, Dr. Kavumba, he asked, why don't you consider Europec for your discussion? Every time you're just calling me as an expert to talk to a group of 10 people. Why don't you consider Europec? And we took it in good faith. So when the events of December happened, what we know that is the issues of Dr. Kiza Vesije and then Aaron Kiza. Aaron Kiza is a mentor under our Youth for Policy in Human Rights Fellowship, where both Dr. Zahara and Dr. Kavumba also mentored. We felt what we owed Aaron was us having a discussion on the future of civil liberties. And I remember when I reached out to Dr. Kavumba, I was like, well, I have a thought here. I don't know whether Europec would be willing to take on this discussion. Civil liberties are under threat, and they have been reduced to a point where we now have to negotiate to enjoy them. And he said, look no further. And he said, let us look at the last week of February. I remember he was in a location where he had taken himself away from the town, and we're having several challenges with network, but we still persisted and agreed to have either the last week of February or the first week of March. Then the Supreme Court announced that finally what you have been waiting for is here. I kept quiet because I didn't want to instruct a whole doctor that maybe we should bring the discussion closer. But of course, as it is, naturally he reached out and he said, you know what? I have now decided that we should hold until the Supreme Court has delivered the judgment. And all of us just said, oh yes, that's what we have been waiting for. When they deliver the judgment, please reach out. And indeed, he did. Why is CAS here? As a political foundation that has been in Uganda for almost 60 years. We are all Ugandans and wish for the better of Uganda. May this discussion be fruitful. May we all live to see what a better Uganda would look like as the Supreme Court judges bequeath to us. Thank you very much.
And the congregation shall say, Amen. Thank you very much, Mr. Samuel Muhindo, Program Manager, Media for CAS. And now for the gist of this afternoon's discussion, military courts or kangaroo justice, unpacking the decision in Attorney General versus Honorable Michael Kabaziguruka. On the 31st of January, 2025, in a constitutional appeal decision, the Supreme Court of Uganda declared sections of the Uganda People's Defense Forces Act unconstitutional. The sections provided for the blanket trial of civilians in military courts, and the court ordered for all ongoing or pending criminal trials against civilians before the court-martial to immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. It is said that this case marks a significant milestone in Uganda's constitutional jurisprudence. As to why our organizers thought to call it a kangaroo court, kangaroo justice. Now, kangaroos are such dear animals. They are such dear creatures. I love them. These are mammals. I read a little bit about them. They have their young in an incomplete stage, and then they keep the young in a pouch, which they and carry them as they suckle them until the young become fully developed. So why on earth would someone say that, some courts are kangaroo courts? Kangaroos are dear creatures. They come in many shapes and sizes. But I also read that they sometimes drown their enemies. Maybe that is the reason. Kangaroo courts are perceived as courts whose proceedings deviate so far from accepted legal norms that they can no longer be considered fair or just. The label of kangaroo court is a severe condemnation and is generally only levied against judges presiding over egregious miscarriages of justice. Regardless, we are debating whether Kabaziguruka's case is a landmark victory for constitutionalism in Uganda. To do us justice on this, we have two panelists, experts in constitutional law, military justice, and human rights, that will lead on the discussion. Our very own Professor Christopher Mbazira. Professor Mbazira is a professor of law here at Makerere University, founder and coordinator of the Public Interest Law Clinic, founding member of the Network of Public Interest Lawyers, NETPIL, very involved in strategic litigation in Uganda, including reviving the place of amicus in court proceedings. Let us put our hands together for Professor Mbazira. We also have the renowned, the quiet, unimposing, but certainly very significant Jude Byamukama. Jude is a human rights practitioner, constitutional law expert. Mr. Jude Byamukama has argued several groundbreaking constitutional law cases as well as cases in electoral law. Mr. Byamukama, we are very honored to have you this afternoon. So to lead us, to start us off, Professor, is this a landmark victory for constitutionalism? Kindly give us a summary of this case, unpack the decision. Where are we coming from? And what gave rise to this case in the first place? What does it speak towards the nature of military justice in this country? Over to you, and I will allow you to present as you sit in your places. Professor Mbazira.
Thank you so much, moderator, Dr. Zahara Nampeo. Good afternoon, colleagues, ladies and gentlemen. A very special note of appreciation to Huripec, the director, Dr. Businje, for organizing this, and all colleagues that have supported this, including our development partners. First of all, I would like to state why this case has been a matter of interest to me. I've just completed the manuscript for a book. The book is entitled Judicial Power, Politics and Constitutional Transformation in Uganda, Working in and Outside the Constitution. The purpose of that book was to interrogate the extent to which our judiciary has been transformative. And I adopted definition of transformation in simple terms, from a constitutional perspective, as transforming Uganda from a country that has been characterized by dictatorship, arbitrary exercise of power, and violation of human rights to a country that is built on the principles of constitutionalism, rule of law, and respect for human rights. So I interrogate the question whether the judiciary has actually supported that transformation. And the book, among others, uses a historical approach, looking at how the judiciary has performed from the independence times into the post-independence period. And one conclusion that I come to in that book is that our judiciary is actually double-faced, in the sense that on certain occasions it's transformative, and it strikes you as one of the best judiciaries on the continent. Indeed, there are many instances where lawyers and judges from other jurisdictions looked at Uganda with admiration, looking at the performance of the Constitutional Court. But also occasions, the other side of the face, and that's when it is transformative, that's when it is working in the Constitution. But there are also so many occasions where the judiciary works outside the Constitution. From ex parte Matovu, Ibingira, and that ghost that, as said by Professor Lokonyango, that ghost that the judiciary has largely failed to exercise. Based on that, when this case came up in the Supreme Court, of course, it started in the Constitutional Court. At the Supreme Court level, for many of us, our expectations were very low. I had the impression that once again, the court was going to walk outside the Constitution. But to the surprise of many, including myself, the court, to a certain extent, tries to walk in the Constitution. But that does not mean that the decision is going to result into improvement in terms of transformation and adherence to the rule of law. I'm not going to waste a lot of time going through the facts, but we know that Honorable Kabaziguruka, a former member of parliament for Nakawa area, was charged before the court-martial, general court-martial, with a number of charges, including treachery or offenses against the security of Uganda. Among others, the facts indicated he threatened to harm the president, and so many other treacherous and treasonable things that were put in his charge. He protested, challenged the constitutionality of the court before the Constitutional Court. One of the key grounds was that the court didn't have powers to try civilians, that it was unconstitutional for the court to try civilians. It was also argued that the procedures, a man of appointment, and that the way the court functions vitiates from the right to a fair trial, and so many other things. And the court agreed with him, apart from one key point where the court said it was convinced that under certain circumstances, the court has powers to try civilians, and that these are circumstances where civilians have committed offenses together with servicemen, that in such circumstances, the court has powers to try civilians. We know this has been the most sticky issue, the trial of civilians, following what happened to the people that were arrested in the run-up to the 2021 elections and after the elections. And as we were forgetting about that, then comes the Besige and Lutare trial, which reawakened the number of cases of civilians that have been tried. Then, of course, as we were still there, then we see what happened to our colleague Aaron Chiza, being found to be in contempt of court, and, without following due process, being convicted and sentenced to serve 9 months. When I went to see Aaron in Chitalia, I saw the register of prisoners, because it is displayed at the reception. And the register had 2,700 prisoners that are detained in Chitalia. And what I learned was that actually the majority of the prisoners there had been sent there by the court-martial, general court-martial. So, of course, the notorious ones that we see, Besige, Lutare, Aaron Chiza, those are the notorious ones that have been covered by the press and media, but there are quite a number that have gone through the court-martial unnoticed and without any public awareness, and serving either awaiting trial or they actually serving several sentences. I know that Jude has represented some, maybe he will share with us. So the court then agreed with him apart from the point of trial, and the Attorney General appealed. And upon appeal, the Attorney General also, in a manner that is a bit irregular, which is not canvassed by the court, actually applied for a stay a stay of execution. I don't know what state that is. I don't know what was being executed. My colleague here, a seasoned practitioner, can guide us on that. But in summary, these are the findings of the court. Maybe I should say something about the opinions of the justices. After a very long time, we saw that the various justices of the Supreme Court, apart from a few who concurred and didn't write much, came up with detailed opinions. We've not seen that in some major cases like the presidential petitions, where we've seen one decision written as a leading decision and then all the justices concur. But this time we had several of the judges actually write fairly detailed opinions that offer quite a lot in terms of interpreting the law. But the court generally makes the finding. First of all, the court finds that the court martials are subordinate courts, which was a welcome clarity, because they are decisions from the Constitutional Court that were actually putting the General Court Martial at the same level as the High Court. And of course, we know that this was to a certain extent politically motivated, to give the General Court Martial some form of inherent jurisdiction, which it's not supposed to have. But the court finds that the court martial is a subordinate court established within the provisions of the Constitution, because it is established by the UPDF Act. And in this, the court is then clarifying that this court is, if it's to be a court anyway, it is supposed to be under the High Court, and its decisions can be reviewed by the High Court. But then the court goes on to clarify that actually this entity is not a court of judicature. Instead, it's a tribunal that was intended to deal with cases of infraction of disciplinary provisions by members of the forces. That was never intended to be a court of law that tries either servicemen or civilians for criminal offenses that attract a penalty of imprisonment. And the court elaborates that in its very composition, in its methods of looking at its methods of operation, the court or the tribunal is incapable, the general court martials, not just the general court martial, but the court martials generally at different levels, are incapable of delivering on the non-derogable right of a fair trial, as detailed in Article 28. And the court looks at the tenets of the right to a fair trial, in addition to the independence of courts of judicature, independence of the judiciary, and it finds that actually the composition, functioning, procedures of the court martials, they are not capable of fulfilling those tenets. They include like 6.1, the appointment procedures. Judicial officers are supposed to be appointed through a procedure that guarantees independence, a procedure that is independent from the executive. In this case, when you look at the UPDF Act, members of that court are appointed by the High Command. And when they take their oath of allegiance, they take their oath of allegiance to the Commander-in-Chief, and they are answerable to the High Command, which blurs the separation of powers between the judiciary and the executive. The court also looks at the composition. The court is composed by serving military men who are still subject to the command structure of the force. And the court actually finds that some of them, or by the nature of the qualifications of who can be appointed to that court, includes junior members. A junior member of the forces can be appointed to the court, and they will be sitting in cases involving their superiors. The court finds that to be regular. The court is also concerned that the members don't have security of tenure, which is a key tenet of independence of the judiciary. You know, right now, when you read the Constitution, the judicial officers have security of tenure. Yes, there are circumstances where they can be removed, but it's not easy For High Court and above, there has to be a tribunal, and the procedures are quite elaborate for a judicial officer to be removed. They retire these days with their full salaries and benefits, which gives them confidence when they are adjudicating cases that they don't have to compromise their independence for the sake of securing their economic future. But the members of the General Court Martial, for instance, are appointed by the High Command to serve for a period of 1 year. Of course, it is renewable, but it's a period of 1 year. The court is also concerned that for the right to a fair trial to be guaranteed in criminal trials, it is necessary for the person presiding over those trials to be trained in the law. That's what we are doing for most of the people in the audience here, our students. We are training you to know how to evaluate the evidence, to know how to apply the facts, to know how to interpret the law, to know how to make the relevant considerations in sentencing, to know your jurisdiction, the scope of your jurisdiction, the scope of the right to a fair trial, etc. But the court finds that there is nothing in the law that requires that the members should have expertise in the law, as much as the court was mindful of the fact that in practice this can be done, but still the court was concerned that the law does not provide for that. Number 5, the court was concerned that the way the court martials are constituted, there is a merger between the prosecutorial authority and then the adjudicatorial authority. How? In the courts of judicature, we know that under the Constitution, prosecution is an executive mandate. And the ODPP, the Office of the Director of Public Prosecution, is still within the organ of the executive. And that's why you see when it prepares cases, it still has to provide evidence to the judiciary. Now, when it came to the court martials, the same court was the adjudicator, but it is also the one that prosecutes the cases. And the law expressly excludes the ODPP from being involved in the prosecution. So the court found that to be a blurring of the lines that separate the different organs of the state judiciary and executive. Then the court also finds that the law, and here the court, I think, was trying to clean up on its decision a couple of weeks ago, where it found that there is no right of appeal from the court martials to the courts of judicature. The backlash from the public was so strong that the court quickly had to clean up, this time by saying, you see, again, we are now saying that this can't be a court of law that can try criminal cases because there is no right of appeal. And the court refers to the obvious, which it didn't refer to in the previous cases, that where somebody is convicted of an offense that attracts a death penalty and sentenced to death, there is an automatic right of appeal. When the court delivered the judgment it did on that a couple of weeks ago, it forgot that very obvious consideration. Then, of course, the court tackles the biggest issue that was a matter of concern to the public, which is the trial of civilians before the court martials. And the court finds that, you see, this court was never intended. It was never intended to try civilians. Rather, the tribunals were intended to try serving men for disciplinary offenses. So in summary, that's the finding of the court. Of course, there are so many other things. The decision as it stands now, to a certain extent, it is a textbook on the right to a fair trial in Uganda. The court then makes its orders. I know my colleague Jude is going to discuss that. I know he's also involved in the implementation of that order. But something of interest to me that I want to touch on, Chair, as I finalize my presentation, is the court distinguishes between what it calls direct and then collateral retrospectivity, in the sense that the court says that its decision that the court martials are unconstitutional is going to have both a prospective but also retrospective effect. And it says retrospectively, the decision applies because the court orders the transfer of cases. It also orders that the trials that are going on should cease. But the court says retrospectively it applies to those cases that are currently pending before the courts, or those cases where a conclusion has been made, a conviction, and the person is either serving a sentence, but only where a step has been taken to challenge the conviction or sentence, what the court calls direct. So that causes a bit of a problem, because it means the court is saying this is unconstitutional, but it does not apply to a certain category of. I know we are going to discuss that in detail. Lastly, the significance of this case, outside the legal jargons, outside the jurisprudence and the law, to me, it lies in the power of civic action. It lies in the power of civic action. Because we know that the delivery of the decision, the judgment judgment on appeal had inordinately delayed. You know, that case has been sitting in court for a very, very long time. Of course, the Chief Justice gave reasons why. Some reasons are cogent and convincing, but some are not. But this case shows how you cannot restrain, or how you cannot do away with civic action. Because it is a case where we saw the power of civic action to push the court to deliver, where so many Ugandans on social media, but also in physical spaces, put the judiciary to task, especially the Supreme Court, to give accountability why a case of that magnitude, and a case that has serious implications for the rule of law and constitutionalism in Uganda, was actually sitting and gathering dust. And we saw a lot of pressure being piled, and this pressure delivered when all of a sudden, out of the blue, we saw a notice from the court indicating that the court was going to deliver judgment in the matter. We know there are so many cases of that nature. In my book, I actually have a section where I profile, because I focus on the Constitutional Court. I look at, I review a good number of cases decided by the court. I look at the period between when the case was filed in court and when the judgment was delivered. The average time is 7 years. So you file a petition, it's going to take you not less than 7 years for your case to be heard. Even when the constitution is clear, the constitutional cases have to be given preference. Meaning when there is a matter of that nature, all other cases should be stayed. But in practice, that's not what is happening. Of course, the courts say the judges are few. We have now seen appointments, quite a number. Hopefully, that's going to improve. So finally, it's a groundbreaking decision. But just as I said, based on the conclusion of my case, of my book, we are living with a chameleon-like judiciary. So as we celebrate this, we should not lay down our tools, because the judiciary is double-faced. Sometimes it is progressive and transformative, then sometimes it delivers judgments, and you read the judgment and think you are dealing with the worst court on the continent. I'll leave it at that for now. Thank you.
Thank you very much, Professor Mbazira. When you mentioned the chameleon-like judiciary, I thought perhaps over the weekend you were dancing to the Nawolovu tune, which is, on the heat waves these days. But thank you very much for walking us through the case. Something that caught my attention is the low public expectations of the judiciary. I think that is a key takeaway, that the public was surprised that the courts delivered a judgment, and to this effect. Meaning that the pattern is that we have a judiciary, as you said, that is walking in and out of the Constitution without a strong position to adhere to constitutionalism and to the Constitution. So that is something to really reflect on going forward. Mr. Jude, now that we've heard about the case, what are the legal takeaways for you? Professor mentioned that the judgment said that the court-martial is a committee. Is it a committee? Is it a trial? What is the legal status, and what are your key takeaways for you legally?
Now, one of the most important things is that though the lead judgment of the Chief Justice doesn't point it out outrightly, there in fact was no right of appeal from the Court-Martial Appeals Court to the Court of Appeal and then to the Supreme Court, even for a death sentence. Justice Catherine Mbazira highlights that because she had written a lead judgment in Lieutenant Ambrose Ogwang versus Uganda. I will talk about Ambrose Ogwang shortly. So a person convicted by the court-martial and the court-martial appeals court had no way of crossing over to the civilian appellate system. And yet the Constitution requires particular sentences to be confirmed by the Supreme Court, specifically the death sentence. So you had soldiers sentenced to death. There wasn't any civilian, to the best of my knowledge, but you had soldiers sentenced to death. And they couldn't actually have their sentences confirmed by the Supreme Court because there was no appellate mechanism to move them from the Court-Martial Appeals Court to the Supreme Court. What existed were regulations under the UPDF Act. The UPDF Act is now Cap 330, but we used to call it the UPDF Act 2005. The Minister of Defense had enacted regulations purporting to create a right of appeal. But a right of appeal can only be created by Parliament, not through subsidiary legislation. So those regulations were rejected by the Court of Appeal in Lieutenant Ambrose Ogwang versus Uganda, and the Supreme Court also had agreed. So it created a very hopeless situation where people who are locked up in the military justice system could not even have their sentences and trials reviewed by the civilian courts. And therefore, people like my client had represented were simply stuck. What I had done in my case, I filed for her a constitutional petition challenging her trial and conviction. And the arguments were simple. The court-martial does not pass the test under Article 28. Now, when we talk about Article 28, many times all of us remember a person must be charged before, must have a fair trial, it must be an impartial tribunal. But the meaning of the word competent, what amounts to a competent tribunal? Competence hadn't been tested, and not so many people had attempted to call out the court-martial on the grounds that even if it were to be fair, did it pass the test of competence? Would these officers, men and women, sitting in the general court-martial, read the penal code and apply it? Do they understand the burden of proof? Do they understand mens rea? Do they care about defenses? Do they understand that an accused has a right to keep silent? What I'm told from a few interactions with members in the armed forces, if you went to the GCM and you kept quiet as you were charged, they would treat that as insubordination. And say, look at this one is even being disrespectful. He's charged and he's keeping quiet. It would even be, you'd be worsening your situation. Because these are soldiers, and for them, what they understand is that if you are charged before them, the first thing they expect you as an accused person is to be respectful, to be as humble and obedient. So if you're an accused person and you go before them and you keep quiet, it even annoys them the more. I remember when Dr. Besige in 2005 was charged before the court-martial, then chaired by the late General Eli Tumwine, and then he appears and then Dr. Besige keeps quiet. General Eli Tumwine got so annoyed and started asking him, he's like, do you have ears? Can't you hear what we are saying? Why are you keeping quiet? And then later, General Eli Tumwine, I remember, cited our senior colleagues, Mr. Caleb Alaka, and then the Lord Mayor, Elias Rukwago. He cited them for contempt of court. Even then. That was 2005. And then Thankfully, he sentenced them to a fine of 1,000 shillings and or imprisonment for I think around 4 hours. So for them, they were lucky to go home and like Elon Chiza. But I remember when he was going to sentence them, he asked that is there any provision of the common law which will be violated if I imprison these lawyers? And everyone was alarmed. But that is the quality of justice that we have had in the General Court Martial for almost, is it how many years? Is it almost 20 years? You have hundreds of people who have been processed through this system. Some of them are languishing in jail as statistics of convicts, but nobody knows what they went through. And then you have others who are accused persons. I have so many stories, I won't say all of them, but in 2009, when I just left LDC, I was interning in a law firm which had a UPDF captain who was remanded by the court martial without a charge sheet for 9 months. And when the charge sheet surfaced, initially it had an offense called breach of contract. And then when the lawyer, my boss I was working for, protested and told the prosecutor that, this is not an offense. He got annoyed and he said, well, even if it's not, what is important is we have orders that your client has to stay in because he knows what he needs to do. Indeed, it was a contractual dispute with another senior army officer. And the gentleman was only released almost 2 years later for a non-offense. So the abuses that have been going on in the military justice system are simply unbelievable. And therefore, when the Supreme Court ruled in Makerere Kabaziguruka that no more trials, no criminal trials in the court martial, it was a relief for so many. It's unfortunate that the judgment does not apply retrospectively, except for those who still had legal challenges before the courts. Maybe to break that down, what the justices of the Supreme Court rule essentially is that even if you were convicted through a trial that is a nullity, and you went and sat in prison and you are serving your sentence and you took no other step, too late. Forever hold your peace. Obviously, it is an injustice. But again, the justices are also worried about causing chaos because while there are those examples I'm giving you of people locked up in the system for non-offenses of whom there's no evidence, there are also genuine cases of people who are charged and convicted by the court martial and who probably would have been convicted in a civilian system. That takes me to Lieutenant Ambrose Ogwang. Lieutenant Ambrose Ogwang was tried and convicted by the court martial and sentenced to, I think, 40 years imprisonment. He appealed to the Court of Appeal. By good luck for him, his criminal appeal went before a panel of the late Justice Kenneth Kakuru, then Justice Egodantende, and I think it was Justice Helen Obola. So they allowed his appeal on the grounds that they considered his initial trial a complete nullity because the court martial was not a competent court within terms of Article 28. So they ordered that he should be retried before a civilian court. Lieutenant Ambrose Ogwang went for retrial, I think, before the High Court in Mbale. And lo and behold, he was still convicted by the civilian court of murder. He appealed to the Court of Appeal. His appeal was dismissed. And then he unwisely appealed further to the Supreme Court. Now, the Supreme Court, unfortunately, did not realize that the appeal they were hearing for Lieutenant Ambrose was originating from a civilian process. They assumed they were hearing an appeal originating from a trial in the court martial. And so Justice Captain Makerere dismissed his appeal and held that they had no jurisdiction because this was a matter from the court martial. Obviously, I thought that's quite embarrassing for 5 justices of the Supreme Court not to read the record and understand where a matter is coming from. And unfortunately, they upheld a sentence of 40 years, which had originated from the court martial. The civilian court had actually sentenced Lieutenant Ambrose to 25 years. So in his quest to keep appealing further, he literally, like they said, died in his own movie. Because now he's serving a sentence of 40 years. And yet the civilian court had given him a sentence of 20. But maybe what his case shows is, while there are these serious abuses in the military justice system, we should not presume that it's everybody who is charged there either for political reasons or is innocent. No. There are actual cases of people who need to be tried, but before the proper court. And therefore, that's why you will see that the Supreme Court decision requires that pending matters be transferred to civilian courts. They did not say there anybody there should go home. I've been a subject of some heated debates online, because when I told people that actually there is no release order by the Supreme Court, people were very upset. But let's repeat it in case some of you get upset. We'll discuss it further. The Supreme Court didn't order a release of anyone. And rightly so. You need to recall that they were hearing a matter involving one litigant, Makerere Kabaziguruka. Makerere Kabaziguruka was extremely lucky. When he was charged in the court martial, he applied for bail before the criminal division of the High Court. And his criminal file was before Justice Yasini Nyanzi, a very good man, a very nice, good justice who is now since retired, who took the view that the court martial is subordinate to the civilian High Court, as the Supreme Court had ruled in Joseph Tumushabe versus Attorney General. So he proceeded to grant him bail. There was nobody opposing the bail application, by the way. Why? When the bail application was filed in the civilian court, guess what? The military prosecutors have no audience in the civilian courts. The DPP had not charged Makerere Kabaziguruka, so the DPP made it clear that her officers had no business appearing to oppose that bail application, because the underlying charge sheet was not from their office. The court martial prosecutors who would be interested in opposing had no audience in the civilian court. And his bail application was unopposed. And Justice Yasini Nyanzi gave Makerere Kabaziguruka bail. And after he got in the constitutional court, Justice Remi Kasule had stayed the trial in the court martial as a single justice. Of course, they see a lot of controversy about single justices' powers in the constitutional court. So Makerere Kabaziguruka, technically, after he got bail, he remained a man up to today. And therefore, there were no specific orders to make in regard to his situation, whether he should be released or whatever. Unfortunately, several matters which are affected by this judgment involved people who are in detention. None of them ever applied to join this appeal. I was tempted to actually apply for one of my clients who is in Chigo to join the appeal. But that was late last year, around November, and I got a gut feeling that my application would do more harm than good and provide and delay the delivery of judgment further. So I chose to leave it. But now what happens is, people who are in prison and who still have active cases. Active cases means they are still challenging either their convictions, or they have not been tried, or they are undergoing trial. Those who are in that category now have to take steps to secure their release. The Supreme Court didn't know about them, and there is no way the Supreme Court would make a blanket order and say, release everybody. Yes, I can see my friend waving his finger. So, because a blanket order would be lumping people together who are in different situations. You have people who are charged, you have people who are convicted and are still appealing. The most fair thing is to say, which I think the justices should have done, probably they could have categorized them. But again, we can't blame them. They would be doing guesswork. They are dealing with a case file of an individual called Makerere Kabaziguruka. All this data is not before them. They don't know that there are people who are pending appeal in a court martial appeals court. They don't know there are people who are pending in the general court martial. There are others who are before the unit disciplinary committee. There are others who are serving sentences, but who are challenging them before the constitutional court. Now, with all those 5 categories, I do not know whether it would be wise to issue a blanket order and say release everybody, let DPP start afresh. It would be very complicated and also unfair from the criminal justice system point of view, that you cannot throw these people and assume they are one. They are those young men and women of NUP who are charged with wearing red berets. Of course, those ones surely need to go home. There is Dr. Besigye. He needs to go home. If they have a case, they bring it before the civilian court. But you have these soldiers who committed offenses in Mogadishu and were charged and convicted by a court martial and are serving sentences. Would you say they should also go home? You don't know what offense they committed. Some are charged of supplying firearms and fuel to Al-Shabaab militants. Some were charged with what? Some soldiers killed fellow soldiers. I mean, there are serious issues like that. So a blanket order, I think it was wise of the Supreme Court not a blanket order of this. What I would fault them for is maybe they should have given better guidance to how the high courts should handle these files when they are brought to them and say, well, if a file is brought and the DPP does not present a new charge sheet, that is illegal detention, release. If a file is brought and the DPP puts in a new charge sheet, let it be handled in the normal way. If the person is applying for bail, they apply. So what we have now is hundreds of prisoners who are in limbo. Prisons is wondering, should we interpret the judgment and release them? Does prisons have powers to interpret a decision of a court and then start releasing prisoners? Or that's a job of another court? But again, like when we talk about Dr. Besigye's situation, his remand warrant expired. He was remanded to a particular day. The day expired. Prisons is saying, well, for us people who are brought here before through the courts of law, if we have not yet received another order telling us to release someone, we don't know what to do. It's a bit unusual. And maybe that's why I think the Supreme Court did leave some gaps. They shouldn't have caused that. They could have given better direction. They could have simply given a window, like they did in Susan Chugora and others versus Attorney General, on how to interpret the rules governing the death penalty. So they left a gap. And now that gap is causing a bit of uncertainty on how do we move forward. The Supreme Court has said my trial is a nullity, but my file should be transferred to a civilian court. The file which is going to be transferred contains a charge sheet sanctioned by an army prosecutor who has no locus before the civilian court, meaning the director of public prosecutions must bring a new charge sheet for there to be a valid file for a magistrate to look at. And that is not happening. Tomorrow it's 2 weeks. It's almost 2 weeks. It's not happening. What if the DPP chooses to keep quiet and do nothing? It will mean individual litigants need to act, or maybe someone needs to move the Supreme Court to provide those categories. There are various options. So the Supreme Court should have given better guidance on how to move of their decision. And then, before the UPDF Act is amended, there is this whole debate. The justices clearly rule no criminal. The justices rule that no criminal trial of an accused person, even if it's a soldier. So one senior army officer asked me that if I'm with my soldiers in Mogadishu and one soldier kills a fellow soldier, the Supreme Court is saying I should airlift him and bring him to Uganda Road and have him tried. Even though the witnesses may be as Somalis. What do I do with my field court martial? Don't I need to act? And I told him, no, you have to wait for the UPDF Act to be amended. And then he said, how long is that going to take? Is it a couple of days? Is it weeks? what do I do in the meantime? And I told him, yeah, you take it to civilian courts. And he said, you civilians don't understand these things. It's not as practical as we think. And obviously, there is need to think about that as well. When you read the concurrence of Justice Elizabeth Musoke, for her, she strongly, actually, it's not a concurrence, it's a dissent on a point or two. Because she takes the view that for her, you cannot have a general court martial established as a subordinate court. And that means, therefore, from the Chief Justice probably should have flagged these orders. It's not an unanimous decision entirely, as the impression that is created is that it's unanimous on everything. It is unanimous on saying the court martial does not pass the test under Article 28. But there are dissents on a number of points. Justice Elizabeth Musoke takes the view that, in fact, the court martial is not a subordinate court at all. It's merely a disciplinary committee. But that position is rejected by the majority. And therefore, on that point, you'd say it is a 6-1 on that question. And when it comes to the question of should the court martial try all criminal cases, others are saying, well, if it could pass the test in Article 28, we would think about it. That could be dangerous, and I think as Parliament and the ruling party try to use their numbers to amend, there's quite a bit of confusion on this area. And that's why it's important to continue to have these discussions. Because in principle, the decision of the Chief Justice says, you cannot try civilians. But if you must do so, you need to first demonstrate before a civilian court that it has no capacity. How is Parliament going to legislate that? Are they going to say before a person is charged in the court martial as a civilian court should first give leave for that? That would be ridiculous. Maybe they should have simply said, you can have your soldiers if you can constitute your court properly within the meaning of Article 28. You can try your soldiers, but please keep civilians out of it completely. Unfortunately, there is a dangerous window which remains open. Because when the Chief Justice says they can only try civilians if they demonstrate that the civilian court is not capable. President Museveni claims the civilian courts have refused to manage Karamoja. It's only his soldiers and the general court martial that have pacified Karamoja. What did they do in Karamoja? In the court martial, you had legate bail. They rounded up Karamojong warriors, a number of them were below 18 years of age, charged them en masse. I don't even think they took individual plea. Well, these are soldiers anyway, so you don't expect that they know the procedures of the teacher accused person must take individual plea and all. Over 200 of them were remanded and denied bail for several months. Luckily for them, some of them had crossed over from the Turkana region and they were Kenyans. They were Kenyan citizens. And the Kenyan authorities protested to Uganda. The president got involved. And as they filed their appeal before the Court Martial Appeals Court, the Court Martial Appeals Court allowed their appeal and quashed the trial of everybody. But the underlying undertone was that they had an instruction from above that, well, let these people go. They are not even Ugandans, some of them. Let them cross the border and go back to Turkana. And that is something which is not going to be changed. I do not know if there are any MPs around or listening in, because this is an important point they need to learn. The court martial is technically under the commander-in-chief of the armed forces. When you check in the UPDF Act, in the schedules, they take an oath to be loyal to the commander-in-chief. They don't take an oath to administer justice without fear or favor, without ill will. No. Their oath is to be loyal to the commander-in-chief. So if the commander-in-chief says, I've sent so and so, court-martial them, they need to act. If he says, no, I've so and so, leave him. I remember the president was addressing police officers at their training school, is it in Masindi, a few years ago, and then he said the army leadership had wanted to court-martial some of the individuals who were involved in the Arua saga with the Honorable Kyagulanyi. And he said, but as far as I was concerned, they beat this gentleman properly. They were defending themselves, so I didn't think there was a case. I stopped them. They were not tried. So a commander-in-chief is above the court-martial, no matter what. How is Parliament going to show that? And he said they cannot create, in my view, it is impossible to create an independent court-martial by very nature. And that is why even in countries which have military courts, they have a mix of a civilian judge presiding over a circuit and then a mix of the members of the armed forces. Why? There may be offenses where even a civilian judge needs to be guided on what is permissible from a soldier's point of view.
I think you are getting us into the next steps,
Yes.
Mr. Byamukama.
So perhaps I think I'll hold my fire here and wait. You can see it running late and
All right. Thank you very much. I could feel that now you are getting us to the next level. Students of gender and the law, I'm sure you're picking up the critical issues for your coursework. The decision will be the basis of the coursework. So start to look at the case and criminal procedure. Please don't be surprised if half the coursework is on this decision, please. So look at the case, the judgment with gendered lenses. So what we have really, the gist of the discussion is that the judgment marks a significant milestone for Uganda's constitutional jurisprudence. No doubt about that. But at the end of the day, it is not as linear and clear-cut as it should be. There are many gray areas. For example, the issue of only prospective annulment of cases. We've had some pronouncements from the Attorney General. He's reading the case. The Minister of Justice is giving us his being optimistic about enforcement. But how do we operationalize the judgment, our dear panelists, and where do we go from here? Yes, we have all these gray areas, but what is the way forward with the judgment and outside the judgment? What are the different steps that can be taken? Professor, I'll start with you.
Council Jude has raised the dilemma created by the court because the court was dealing with Kabaziguruka and not every person that has gone through those courts. And in this, the court therefore was inclined towards the tenets of corrective justice. You know, you only deal with what is before you and you correct that. Instead, the court should have been swayed by the tenets of distributive justice, which requires that you broaden and look. And indeed, the Chief Justice, to a certain extent, towards the end, says that this is a matter of public importance. And then he goes into the other cases. It's like there is no precedent. Actually, the court has tools it should have used. The court should have borrowed from the case of State versus Makwanyani, the South African case, where the court abolished the death penalty. But at the time of pronouncing the decision, the court didn't know how many people on death row. The court didn't know with what the nature of the murders that they had committed, and when they were sentenced, how much time they had served, because the court's ultimate order was to have those sentences committed, but it had to get the details. So what the court did, it exercised its powers under a structural injunction, where the court retained jurisdiction and ordered the state to compile information on each of the people that were sitting on death row, and then to propose or to indicate to court how it intended to commute. And the court handled this process with the state for over a year until the court was happy that all the sentences had been commuted, and based on that to say we have now closed the case. Now, in our case, a few years ago, that would have been impossible because the court had not embraced the structural injunction. But thanks to my PhD research and the amicus that I did in 2016, where we pushed the court to embrace the structural injunction, and it has exercised this severally, it still had the tool. So Jude, what the court should have done was to retain jurisdiction and say within a week, submit to us the list of all people that have been convicted by the court, the nature of the offenses, the sentences, how much time they have served, submit to us indications, how do you intend to deal with each of these cases. The court should have retained jurisdiction, I think, for a period of like a month, reasonably. That would have been enough because the records are there. Although, Jude, I'm told that sometimes the General Court Martial has no record of proceedings. Yeah, so I don't know, but at least the prison authorities have some information that they should have used. So the court forgot about. I think it's one of those cases we didn't think about it, where as a school of law we should have done another amicus and guided the court on how to handle that dilemma. Is it too late for the court to do that? We know we haven't seen the letter. Jude, have you seen the letter? The Attorney General has written a letter. I would really love to see that letter and how it reads. But probably one could argue that letter, it does not have so much legal basis, but pragmatically one could argue it opens up the jurisdiction of the court again. Let the court issue a structural injunction. If it has doubts on how to do it, let the court come to School of Law. Thank you.
The professor has spoken. Thank you very much, Chris. Jude, where do we go from here? What are the legal implications and what steps can be taken practically to take us from this dilemma?
So what I see, one, individual litigants, people who are, especially those who are prisoners, who are on remand or who are serving sentences, need to move the nearest civilian court. We are still having a debate in terms of procedure. You know, for us practitioners at times, we get obsessed with which is the correct procedure. There is a debate. Do we file habeas corpus applications? Do we file judicial reviews? Do we apply for unconditional release? And especially because if we use real life cases, Dr. Besige, I think, has applied did the habeas, although he seems to have a better window for himself because he has an ongoing criminal case at Uganda Road, which is different. And he has bail on that case. I'm wondering that the prisoners people bring him for that case. Would they take him back? And on what terms would they anyway? But people who are serving, like of course, I've told you, one lady in Chigo prison, Elizabeth Chomhan, whom I represented, who had a case in the Constitutional Court. And it's actually an interesting case for those gender and the law students because she was convicted of having allegedly murdered her husband. For her, the Constitutional Court specifically they made a ruling when I appeared before them last year in November that they would not determine that petition until the Kabaziguruka decision. And in the case the Kabaziguruka decision left them with a residual role to play, then they would fix my petition again. So now for her, I simply need to move them to go before her, and I say she needs to go home, or you may have to send her to a civilian court for a retrial, though she has already served over 12 years of the sentence. So I don't know whether it would be fair to subject her to a retrial. So there are cases like that. But I also foresee the need for an omnibus application to be made to try to ask these justices to give guidance. But of course, with a caution always. What happens if you file that application and it is not heard for the next 6 months and the Attorney General says, well, I had started moving the process, but now there is an application, we have to wait for the court to decide. So it's not as straightforward as it looks. There is pushing the court to weigh in, and then they eventually weigh in, but they take their time. And then it also may create a cover for the Attorney General. Right now, everybody is naked. The Attorney General cannot defend anyone who is detained at the moment. He has absolutely no defense. There is no charge sheet from the DPP. There is no charge before a civilian court. Meaning, any individual who is able to move by themselves likely stands a chance to walk as soon as possible. Would that chance remain if there was an application in the Supreme Court asking the Supreme Court to provide better guidance? It could create room for abuse. So that's just a word of caution. What I think if maybe like our public interest clinic here could say, who are these people? I'm sure the statistics are being prepared. Prisons is going to have them released. If someone gets hold of those statistics and says, okay, we are going to do this by case basis until we are sure everyone has been dealt with, wouldn't that be better than trying to encourage the justices? They took 4 years, and you find another application before them. And then before you know it, let's begin with the obvious. The panel had 7 justices. Lady Justice Faith Mwonda retired, meaning a new justice will be joining the panel. And what if that justice says, these 300 pages, I need to read them, internalize them, understand, and then that's when I can weigh in comfortably with my colleagues. And that might take 4 months. So there are risks in that approach. I'm not saying it is wrong. I'm just thinking, is it the most practical? If we had everybody out, maybe we could have that debate. But I can't give even statistics, but there are so many people affected by this decision and who are looking out. We get calls from the prisons. Counsel, what do you think? I was convicted by the court martial. And you ask, so what are you doing? He says, I'm serving my sentence. Do you have any appeal? No. And then you have to tell them, for you, I don't know what to say, but you are not covered. So it's a challenging situation. And I don't know whether it is the most fair. I still think maybe on a case-by-case basis, they should have allowed room for even people who are serving sentences to intervene. Of course, for Aaron Chiza, we had already filed several things. Thank God we did so in time. Otherwise, he would be staring at the full sentence. So practically, those steps, they are a case-by-case basis, may be useful for some. But again, most prisoners do not have the legal resources, do not have the social support to actually have people representing them. So there could be maybe a project for the law school here in that area, because most prisoners are indigent. They don't have the resources. Even people who have resources, after you spend 3-4 years in prison, the few resources you had probably are no longer there. And therefore, unless they are determined teams of people helping them, you may have people who are beneficiaries of the decision, but who may not benefit because the machinery may not help them if nobody takes quick action. I have tried to ask colleagues at the Directorate of Public Prosecutions whether they have started processing any file. They said, no, we have nothing. We were told we should wait. And remember, the order says, transfer the files to the civilian court. They didn't probably think through that those files contain charge sheets sanctioned by army prosecutors who, once a file goes, they have no locus there. Maybe the judges should have said, if a case is at this stage, go home. However, the DPP has the jurisdiction to charge you afresh if they deem it fit. There could be people who are in that category. So it's a bit challenging. For individuals whom we know, legal steps are going to be taken. Mr. Aaron Chiza has also a habeas application. We are going to ask the judge to tell us. The Supreme Court said anybody who was convicted and had a pending challenge must be handled by a civilian court. Do your job. But what about the 300 people who are serving sentences in Soroti prison, in Arua? Who is going to know them? Who is going to think about them? So it's a wider issue. The practical steps still require, there's still a bit of work to be done to ensure fairness for everyone.
Okay, thank you very much. We are at a crossroads, and I think it is a learning time and a learning point for Uganda, where the procedures to be followed are not very clear. We also have, different movement of troops. We've had a chief of defense forces making different utterances. The president has said other things. There are talks about amending the UPDF Act. There's a lot going on. So whatever approach needs to be taken has to be multi-pronged. But it is time now to hear from the audience. Perhaps some brilliant ideas will be shared that Councillor Jude and Professor Chris will then take forward, and URIPEC, to see how we deal with the after effects of the Kabaziguruka case. That one. Okay. Any comments, questions? Please tell us who you are, and in a minute or less, ask your question. And this comment, this also applies to you, Mr. Malay Mabirizi. 1 minute or less.
What is your take on the manner in which the judges of the High Court are chosen? Because we have someone like Simon Peter Chinove, who stood in the NRM preliminaries and lost to Pius Wakabi in Buyaga County, who has now been chosen to be an acting judge of the High Court. So I need your comment on that. Thank you, sir.
Thank you. We shall take several. Let's take another 3 so that we have 5 questions and allow the panelists to address them. Professor Chris, just also to expand on this, is there any connection to the post-2026 elections environment? Any cause for concern for us as legal scholars, seeing that there will be a lot of electoral issues coming to the High Court and the Court of Appeal at this time of appointment of judicial officers? I don't see any other hands. Okay, yes.
Thank you so much. My question goes to...
And you are?
Humza Emmanuel. I'm in my 4th year. My question goes to Counsel Jude. In circumstances where we've said that let the military courts try military people, let the civilian courts handle civilians. We are in a situation where a military personnel, a military officer is caught in a criminal act with an accomplice who is a civilian. Maybe there is a deal of moving arms from one place to another, maybe to Somalis. But the person who has moved those arms is a civilian, using a civilian truck, but with a deal of a military officer. In circumstances where those 2 people are arrested, what will happen? Will they take the civilian person to a civilian court, then a military officer to a military court? Then when time for evidence comes, what will happen?
Thank you very much. 4th comment, yes, goes to the lady at the front.
Good afternoon. My name is Isabella Kankwasa. I'm in 3rd year, the school. My question is to both the panelists. What then becomes the relevance of a presidential statement? And secondly, the fact that the court-martial has its oath and allegiance to the head of state, what now then becomes the effect of its effect on the political landscape? Because Doctor talked about the fact that the politics, next year we are looking at the general elections. And as much as this is groundbreaking jurisprudence for us, but then we are looking at the political hand becoming stronger than the arm of the judiciary, which is the arm and the voice of the people. Thank you.
Thank you very much. And the last one?
Yes. Good afternoon, everyone. Once again, my name is Jude, and I'm a 4th year law student at Makerere University. My question sort of ties into Counsel Isabel's previous question, but it's particularly directed to Counsel Jude. And it raises the question that should we still consider the president as the commander-in-chief of armed forces? Is that something that is still viable? When you look at reception clauses and how the law was adopted, this is the colonial norm. Do we still have to consider a situation whereby we're looking at this military man as being in charge of waging wars on our behalf? Or can this be something that is potentially amended to promote separation of powers and to maybe sort of weaken the sort of political arm of the General Court Martial? So this is something that we should really, really think about. Do we really need the president to be the commander-in-chief? Or is this something that we attribute to having a military man? What if we have a civilian? What next? Thank you.
Thank you very much. I can allow one more at the front. He has really raised his hand, so I'll be kind. the last one, and then we'll allow our panelists to respond.
Thank you very much. I'm Robert Okot from Silicon Advocates. Mine is on the role of the Attorney General. At least after the Constitutional Court decision, most people thought that maybe the Attorney General should not have appealed that decision. And then again, when you look at how the Attorney General has been behaving on politically motivated prosecutions, shouldn't we be advocating for an Attorney General that is independent from the executive?
Thank you very much. Over to you, panelists. Professor Chris.
Thank you so much for the questions. Let me start with the question regarding Counsel Chinobe, soon to be His Lordship, Simon Chinobe. Mind you, Justice Owiny-Dollo one time was a politician. He became Chief Justice. He was a member of Parliament as well. And the minister, Kanyehamba was, so was Katurebe too. In other words, in principle, there is nothing that stops people that have vied for political office from joining the judiciary. There is nothing that stops them. But once they do, they take an oath of allegiance, which is to abide by the Constitution, which is to administer justice without fear or favor, to be independent. So my expectation is that His Lordship, once he becomes His Lordship Chinobe, will take that oath of allegiance, and once he does that, he's bound by that oath of allegiance. We've also seen justices and judges that are politically partial. Not all of them have vied for political office before, so I don't think vying for political office is actually the problem. It's a question of a person not being principled and abiding by the Constitution and the oath of allegiance that is taken by people joining the judiciary. 2026, when the court issued its decision on the 31st, I quickly celebrated as an individual and said, oh, at least we are going to go through the campaign period without this court. That was my celebration. But then later I thought about it quickly and reflected on the lightning speed with which certain legislative amendments are processed through Parliament. So, moderator, what do I foresee? I foresee a thunderous lightning process of amending the Act to ensure that this instrument is actually available come 2026. So what I foresee in the coming few months, we are going to have an amendment that is going to be processed through Parliament. My consolation, though, if the decision that was made in the caucus is something to go by, my initial fear was that we are going to see tinkering with the Constitution, and especially to put the General Court Martial at the same level as the High Court. But if the decision is to amend the UPDF Act, it means that that risk is gone, although we may be surprised that the attempts of that nature, but at least it still leaves us with room to challenge the constitutionality of any amendments that come. But whether that's going to be dealt with in the coming 2-3 years is another question. On the question of the president's statement, it is not new for the president to protest whenever a decision is made that is not in favor of. Way back as 2002, the president has always protested. We've seen him recant what I call counter-majoritarian concerns, where traditionally executive players are not happy with the courts, have always played the courts against the people, to say it is the people that are supreme, it is the people that decide. But the key thing is that the Constitution is supreme. And the president, whether it's the commander-in-chief, whether it's the head of state, is still bound to follow the Constitution, and that law gives the mandate to adjudicate matters of constitutionalism to the courts. And once the courts have adjudicated in line with the rule of law, executive is supposed to abide. Lastly, moderator, I was checking on the position of Uganda on the rule of law index. On the rule of law index, Uganda stands at position 126 out of 142 countries that are measured on the rule of law index. And out of 100, Uganda scores 36%. So Uganda, in terms of rule of law, already has a retake. But as we are going to see so many retakes
That
in your
is a very, very bad retake.
yeah. But yeah, I think that this decision gives Uganda the opportunity to undo that retake. I think the people that evaluate countries on that scale are looking at how Uganda is going to respond to this decision. If we implement that decision according to the orders, according to the directives of the court, and ensure fairness and ensure that there is compliance, we are likely to climb on the rule of law index. Maybe we may climb from 126 to 80 and maybe get 49%. If we get 49%, the practice here, we convert that to a 50, then maybe we shall be converted to get a pass. Thank you. I'll leave it at that. Jude will answer the question on the role of the Attorney General. And Jude will also answer the question on the decolonization of the office of the Commander-in-Chief. Thank you.
And of course, our rule of law score would grow higher if Professor Chris is on the Judicial Service Commission.
The structure under the Constitution is that the head of state must be a civilian, and the military is subordinate to civilian authority. So when you ask that maybe the head of state shouldn't be the commander-in-chief, yeah, it's a bit funny. It is the structure world over. In democracies, the commander-in-chief of the armed forces is the head of state. That's how it is designed, because the military is required to be subordinate to civilian authority in a democracy. Otherwise, if the military is not subordinate to a head of state, then instead you create a system where the military becomes ultimately more powerful than civilian authority. And therefore, the structure in our constitution, and indeed in most constitutions world over, is that the civilian you elect as the head of state is the commander-in-chief of the armed forces. And so there is nothing wrong with that structure. The problem we have with our country, with Uganda, is that President Museveni started off in 1986 as a military man, and then we are simply supposed to presume that he retired from the army and is now a civilian. But we can only test this the day we have another president who is not President Museveni. That's when we can know whether this thing of the military is subordinate to civilian authority works or whether it is just on paper. But the structure, in principle, there is nothing wrong with the head of state being the commander-in-chief of the armed forces. Regarding the role of the Attorney General, again, you have to remember under Article, I think it's 119, the Attorney General is the principal legal advisor of government. The Attorney General is actually technically a member of cabinet. And therefore, it can't make sense to say you have a neutral Attorney General who is not part of the executive. Because the Attorney General is answerable for the acts of the executive. So the Attorney General is part of the executive. The debate we can have is maybe the Attorney General should be mindful of his or her overriding duty to the public good in advising government. When it comes to whether there should have been an appeal in this matter or not, with the benefit of hindsight, I think this appeal was useful for all of us. Because the decision is much better. First of all, the Kabaziguruka decision at the Constitutional Court was a 3-2. There were two justices who dissented. Justices Christopher Madrama and I think Stephen Musota dissented. And so a 3-2 decision. It is not easy for a 3-2 decision to be used to cause for Parliament to cause wide-ranging changes based on a 3-2 decision. Because they will keep saying, it was a difference of one judge. One judge could have swung the pendulum the other way. But now we have a decision where 7 justices of the Supreme Court, the final court in the land, have weighed in. So can we say we should criticize the Attorney General for having filed this appeal? At that point, all of us were not happy. I wasn't. But with the benefit of hindsight, I think it's fine. And what he did was not unusual. Joseph Tumushabe also went up to the Supreme Court. The Attorney General then also appealed it. Again, Uganda Law Society Attorney General, that was in 2007, was also appealed to the Supreme Court. Why? When you have a matter involving such a fundamental question on military justice, it is only fair that the Supreme Court should have the last word. It gives everybody closure. And therefore, it may not be, there may be other reasons. Someone may want to criticize the Attorney General or not. Should there have been a stay? Should he have sought a stay of the decision or not? Why is he getting stays when other occupants of the office never used to bother about that? But well, again, we have to understand that the incumbent Attorney General is someone who came from private practice. And our method and approach, we private practitioners, is slightly different from that of politicians. A number of the other occupants of the office of Attorney General were even members of Parliament. And therefore, they would think about the political role. Some of them would be too busy to follow up these legal nitty-gritties. And so when you get a person who occupies the office with a private sector mindset of, I must win every battle I get into, of course, you'll get a different approach by the office of the Attorney General. It has its merits, it has its demerits. It's a debate that can go on. When a civilian is charged with a soldier, does the soldier go to the court martial and the civilian go to the civilian court? First of all, to clarify, the section in the penal code, the section in the UPDF Act, which provides for the offense of aiding and abetting a service offense, was declared unconstitutional. In other words, that provision now, unless it is reenacted by Parliament, which cannot happen because that would be violating Article 92. It kind of rests the debate. Aiding and abetting a service offense was scrapped from the UPDF Act. But for practical terms, you consider it, for example, if a minor who should not be charged in a civilian, with adult, commits an offense with an adult, the practice is that the minor will be charged with the adult, and not the other way around. But we are lucky that that provision was declared unconstitutional, and I do not think it can be reenacted. And maybe this is why I should comment about the amendments. The justices of the Supreme Court have actually asked specifically for amendments to be made to the Act. And therefore, we should not be alarmed or complain if a process to amend the Act is ongoing. I know for sure that there was a bill before the judgment was delivered. There was already a bill. But that bill was very limited in scope. It was mainly trying to provide for a right of appeal to the civilian court of appeal from the Court Martial Appeals Court. But now the Supreme Court has given them enough homework about the changes they should make. And the question maybe is going to be whether the majority MPs from the ruling party are able to withstand pressure to try to reenact a provision and smuggle back civilians into the law and take us back to the courts. But if they are able to resist that temptation, there are changes which were necessary still. There is still a lot of debate that's going to have to happen about criminal offenses. Is the army going to agree that the Judicial Service Commission should determine who heads the court martial? Wouldn't that be too much civilian intrusion into the military as well? Why not make it the other way around and maybe say you provide a justice? As far as I'm concerned, if you provide for powers of review and supervision in the High Court over what goes on in the court martial, you may not need to worry so much about how you structure the court martial. Cut off criminal offenses, and maybe think about which criminal offenses should a general court martial hold. All military courts world over can impose a sentence of imprisonment. I can see the general sentiment by the justices is that a sentence that is too serious requires a totally different kind of court. maybe there is need for some benchmarking by the military and by the executive on how other countries are managing their military courts. And that takes us to the elephant in the room, the abuse of the military courts in Uganda for political purposes. We cannot avoid that discussion. Kabaziguruka was charged because he was a member of parliament who had just won an election representing Nakawa. The question of whether he was guilty of an offense or not it remains quite suspicious. And by the way, there is a similarity between the offenses Dr. Besigye was charged with in the court martial and what Kabaziguruka had been charged with. So there is, it is not entirely outrageous for us to presume that this is a template charge sheet that is used for particular purposes. So it is that is the biggest danger of our military justice system. It's abused for political purposes. Like I indicated, they hardly give bail to anyone. Imagine, they charged some youth with wearing military fatigues, and they are denied bail for 4 years. And the offense they are charged with probably they wouldn't even be sentenced to 2 years imprisonment. What is that? And they were charged right in the middle of a political campaign. Therefore, it is critical for us to think about the abuse of the military courts for political purposes. And maybe that is why the general sentiment among members of the public is that, but can't we survive without having a court martial anyway? But well, we have soldiers, and they need to have a tribunal that manages them for their purposes. As to whether they should be charged there with crimes, my personal view is that yes, for certain crimes, they should be charged there, for sure. That's my personal view. But civilians, keep out the civilians completely. Keep out capital offenses completely. And then focus on offenses which arise in the ambit of operations. Well, I would ask you to read the recommendations, in my view, by Justice Catherine Mbazira, appear to be more practical, and maybe the Chief Justice should have borrowed them. Unfortunately, it's a view of one justice. Nobody adopted it. But I like her proposal about having a status of offender determination. In other words, she proposes that before anyone is charged with a crime before the court martial, let the High Court make a finding on the status of this offender. Will justice be best served in the military court or in the civilian court? That could be a good safeguard on abuses by the military court. But as has been alluded to, let us not have too much blind faith in the civilian courts and assume that all is rosy there, they know the due process, they administer justice without fear or favor. No, they don't. I will say so.
Yes.
It's about the political landscape, like one of you was alluding to. When I look at the judiciary that existed in 2005, I was a third-year law student in 2005. When we had the likes of Justice John Bosco Katusi, and then I see the judiciary we have now, I'm a bit worried. I don't know whether we have, whether it's, I cannot for sure say that there is a better judiciary now. In terms of numbers, yes. The quantity is more. That we can concede. We have several high court circuits. There's a high court circuit in Kabale, there's a high court circuit in Arua, there's a high court circuit in Moroto. We now have 21 new judges have been appointed. The quantity is there.
But the quality
that is a debate for another day.
Okay, thank you very much. Can we put our hands together? Ladies and gentlemen, for our two panelists, I believe this afternoon we are more knowledgeable, not only about the case, we have an in-depth appreciation of the Kabaziguruka judgment, but our panelists have also given us insights beyond the case to discussing broader implications for Uganda's legal system. For a fact, we know that the judgment establishes civilian supremacy over military courts. Maybe there is some hope, maybe there is less hope about judicial independence in Uganda, but there are clear affirmations from the judgment on constitutional protection of fair trial rights. But it also, this discussion also leaves us with questions on how we should engage as legal scholars, as civic actors. What are the legal reforms that are necessary in order to align military justice with constitutional principles? We cannot do away with military justice. As Mr. Byamukama has said, they need to have their own form as the military, but how do we align them with our own civilian justice? So thank you very much, gentlemen, once again this afternoon for giving us those insights.
What the Supreme Court judges agree to, which is in the lead judgment of the Chief Justice, I think on around page 200 something of his decision, he points out the doctrine of prospective annulment, which basically says absolute retroactivity of court decisions may cause an injustice, is accepted in many jurisdictions. In other words, a declaration that an act or omission was void does not necessarily mean you should undo whatever happened before. Why? The doctrine states that many times you have people who have acted in good faith on the presumption that an act of parliament was valid. If I'm a prisoner, I have served my 5 years, then tomorrow I go out and they declare that now the judgment applies to me because my trial was null and void. How does that help me? You could say maybe I go and get damages, but can I unserve the sentence? I've served it already. It's too late. So the doctrine basically also exists, one, to avoid absurdities. And then there is also this whole issue of, in constitutional law, what they also call the doctrine of state necessity. The fact that if a lot of actions have been done on the presumption that an act of parliament is valid, if it is subsequently nullified, it may not be practical and fair to nullify every single thing that was done under the authority of that act of parliament. We had our own Supreme Court applied this in when the referendum act was nullified in one of the last Makerere case. I think that is the appeal of 2004 or 5, because there was an argument that the NRM government had been elected on the basis of the referendum act, and the Constitutional Court ruled that the referendum act was void. Did that therefore mean the sitting government was illegal and everybody needed to go home, from the president to the members of parliament? Would that make practical sense? So because of that, the judges clearly try to invoke the same principle. They say absolute retrospective application of the judgment could cause an injustice to some people. People who have operated on the basis that whatever the court martial was doing was valid. You have people who got pardons from the court martial last year, who went and pleaded guilty. What did you do to them now? If you say everything was void, you are saying Olivia Rutaya should be charged afresh before a civilian court. Is that what you want? She spent 4 years on remand. Clearly it was a frivolous offense. She realized she was not about to get out. Yeah, that's why it's good to visit prisoners and give them faith and hope that sometimes they need to be patient. She realized everybody was leaving her. People pleaded guilty and were promised, when you plead guilty, you are walking home. We are sentencing you to the time you have spent on remand. And then she pleaded guilty and indeed went home. Then the Supreme Court says, by the way, that court where you pleaded guilty was operating unlawfully. Whatever it is doing is null and void. If we are if we are to take the reasoning that everything was null and void, so we should start afresh. It also means those who pleaded guilty and went home should be charged afresh in a civilian court. I don't know whether that is whether Mariam would love that. I wouldn't love it. And that is the absurdity, which sometimes the doctrine of prospective annulment operates to cure. And that is why not everything declared void will be untied and undone.
Okay, thank you very much. I think we couldn't have gotten it better. Another hand clap to our panelists. I know that Counsel Jude Byamukama tried to reopen the proceedings, but since I'm the leading judge on this panel, I call this session to a close, and I thank you once again for giving us the time as the School of Law. Let me now lead us into the closing session and invite none other than the representative from CAS, Mr. Samuel Muhindo, to bid us farewell and tell us if they have any brilliant ideas how we shall take this forward. Mr. Muhindo.
I've been relying on the tweets of Mr. Male, son of Loyola and a gentleman, the partner at Upmark, Dennis Kusasia. So during the entire judgment, that is where we found the easily digestible commentary about the entire process. But today, I think I leave a better person than I came. I'm sure most of you would share the same sentiment. On behalf of CAST, there is a Uganda proverb that when a guest comes and leaving, they promise to come back once again. We promise to come back once again. Actually, Anna is on a flight traveling to Brussels with the team from Uganda. So she had the opportunity to log in and she said, I think we will come back once again. You have a full house out there. And indeed, it was a full house. We discussed and we are much better being at Huripec. Thank you very much. Good to see you, Dr. Tim.
Thank you. Thank you very much, Mr. Muhindo. We look forward to hosting you, welcoming you back to Huripec and doing more work together. Thank you for the partnership. And Dr. Kabumba, to wrap up.
Really, mine is to thank everyone, the audience for coming, colleagues from the School of Law, Patricia, the team, our visitors who came from Columbia University Law School. Yes, very welcome. Colleagues from civil society and the legal fraternity, the rule of law champion. Thanks for joining us once again. Godwin, Toko. I don't know whether you have been stopped from entering the other colleagues that are here, the project staff from Huripec, Geoffrey Obo, Lona Foyomungu, Mary Auma. Really friends. And of course, last but by no means least, our excellent panel, Professor Chris Mbazira and Counsel Jude Byamukama. I'm sure you can all see why this was the best panel we could ever have to discuss this topic. Finally, of course, our excellent moderator, Dr. Zahara Nampeo. Thank you so much for guiding the discussion and keeping us to the time, keeping us honest to the time. Asante sana. Finally, Cass, it has been a pleasurable partnership. You called, we spoke. It happened, it has been respectful, it has been meaningful. And I hope for us as Huripec, we can have more of these engagements with your support and collaboration.